these individuals are not lawful combatants because the attack was specifically and strategically placed against non-combatant civilian populations. Therefore, their rights are waived, do not factor into the interrogation tactics that we use and that are defined in the convention, precisely because they are not lawful combatants. So strategically, whether you like it or not, it is an attempt, at least I'll determine for you to determine whether it was effective or not, but it is an attempt to undermine the very basis of the accusation that was launched by Priest and Gelman. And then lastly, I think this is the last bit for our final section on torture, is that the use of sleep and sensory deprivation, uncomfortable or painful postures, or even a level of physical abuse does not meet this test. Indeed, to say these practices do ultimately trivializes the torture that does take place in so many areas in the world. And the idea is, listen, hold on one second. The idea is, listen, if you argue that this constitutes an act of torture, if you say that stress and duress techniques constitutes an act of torture, then insofar as you make that allegation, you, quote, ultimately trivialize the torture that actually does take place in so many areas of the world, right? And I can only imagine. You can imagine, maybe finger amputation and so on. I'm not going to get into the descriptive ways in which individuals can be tortured. Use your creative, sadistic mind to think of what it might be, right? The argument in defense is that there's a clear demarcation between stress and duress and, putting someone in hot oil, right? It's two different levels. And it's that precise distinction that becomes problematic, right? So in discussing torture, we recognize that the idea of custodianship was a seminal idea in the discourse of torture. And the example that I gave at the beginning of the discussion had to do with the Rodney King beating, and we said that since his custody had not been attained, and for those of you who are not in the States, the Rodney King beating, I think everybody in the world knows about the beating, but at the time, young black man arrested by police, I think he might have had a DUI, might have been intoxicated, beat savagely, recorded, and then a trial ensues, the police officers are acquitted of the charges, and riots break out. Okay, so the Rodney King beating, if his beating was exactly the same, in exactly the same severity, in exactly the same nature, but it took place within the custody of the police in some detention center or a prison system, then it would constitute an act of torture. It doesn't constitute an act of torture prior to the definitive attainment of custodianship. In this case, custody had been attained, and allegedly, it seems, stress and duress practices or techniques were used, but the point is, one, that stress and duress practices aren't torture, because look at what other communities of interrogators are doing. They're doing this, they're doing that, they're doing this, we're not doing that, that's torture, what we're doing is not torture, right? I'll leave that to you to decide if it's legitimate or not. That's not my point here. The second point, which is a more logical, more thorough intellectual critique defense, is to say, not only is it the case that those stress and duress practices do not constitute acts of torture, but the assumption that individuals, terrorists, who attempt to attack foreign nation X, insofar as you attempt to attack the nation, and you do so by strategically and specifically targeting non-combatants, civilians within the population, then you ultimately undermine any rights that you would have under the 1949 Geneva Convention, right? So the very act of targeting non-combatants as your sort of strategical act of war in itself violates any rights, because you're not targeting military personnel and military armed officers and so on, right? So that ultimately undermines the authority of any claims to human rights, right? You forego those rights. Now, the question is that legitimate, right? Is that a legitimate case simply because the individual attacked non-combatants? Is that a legitimate case to then say that they do not qualify and I guess this is more of a legal discourse, right? Is it legally the case? Intellectually, it's a different discussion, but is it legally the case to say that the individual perpetrator of acts of violence against a nation loses lawful combatant status insofar as they have attacked the civilian population, right? So what was important to recognize in this discussion, the accusation and the defense in this specific case, but also as we saw in the Landau Commission report, my point in presenting this information obviously is as a conflict resolutionist. That's what I do for a living. I train peace activists by the masses. It's important to recognize that an attempt to justify the use of torture by any state, anywhere in the world, undermines the national security interests of the state. It would be like national security taboo 101, right? The practice of torture, there's too much to be lost. There's too much to be lost. There is potential endless threat to the nation if and when that information is leaked to the public. And not only that, insofar as you legitimize or you attempt to justify participation in an act of torture with other prisoners, you have to recognize that you inherently put your own military men and women in harm's way when they're abroad, right? So it's just obviously going to result in more and more escalation of the conflict and eventually more and more sadistic practices of torture on both ends, whether acknowledged or not. So with that, I want to end there. This concludes my discourse on human rights and torture. I hope it was a good educational opportunity for you to learn something new. With that, I want to thank you for taking your time to watch my videos. I'm Dr. Jason J. Campbell. Have a good day.